Hi, I'm Karen Friedman Agniflo with Legal AF, and this is Legal AF After Dark. If you missed the midweek episode of Legal AF this week, where Ben Meiselas stepped in for my co-host Michael Popak, who's busy and on trial, in the Jack Smith asked them to, so that the trial actually can happen. The Jan 6 trial can actually happen in March. So if you want to hear what's going to happen with the special counsel versus Donald Trump, it's actually the United States of America versus Donald Trump, brought by Jack Smith, the special counsel, about the January 6 case in front of Judge Tanya Chutkan in Washington, D.C. If you want to hear what's going to happen with that and what's going on with these applications to the United States Supreme Court on presidential immunity, then listen now and join us every Wednesday and every Saturday for a full Legal AF, the intersection of law and politics. If you want to hear all things that are going on, whether it's Donald Trump or any of the other MAGA people who are trying to steal our country from us, then Legal AF is for you. So join us and listen, take a listen.
We last left off, we were talking about what Donald Trump just filed with the United States Supreme Court. Why did he file it on December 20th? That was the deadline by 4 p.m. Eastern time in response to special counsel Jack Smith's direct petition to the United States Supreme Court that the court, the highest court of our land, hear this issue of absolute presidential immunity on a direct appeal. This after the federal judge presiding over the criminal indictment of Donald Trump for trying to overthrow the results of the 2020 election, Judge Tanya Chutkan denied Donald Trump's motion to dismiss the indictment against him on the grounds of absolute presidential immunity. Judge Tanya Chutkan previously held that the text, the structure, the history of the Constitution is such that it makes no sense that former presidents can claim absolute presidential immunity for criminal conduct while they were in office. Similarly, the D.C. Circuit Court of Appeals in a civil context, not criminal context, a civil context, monetary damages, ruled in a case that was filed by D.C. police officers and members of Congress in a lawsuit against Trump for the insurrection, that in that case, Donald Trump was not entitled to absolute presidential immunity because his conduct involved campaigning and election activity, and that falls outside the outer perimeter of Article 2 executive authority. Notably, Donald Trump's lawyer, Alina Habba, has been running around on stages, on right-wing influencer events like this Turning Point events, and she's been, given speeches in all the right-wing echo chamber media on Fox and elsewhere saying, we want the Supreme Court to intervene. We want the Supreme Court to hear this. Also, you had Donald Trump's lawyers at the very outset when this indictment was unsealed. They gave all these media interviews. What were they saying? We're going to immediately bring an absolute presidential immunity motion, which they didn't. They waited many, many, many months before doing that as a intentional delay tactic to wait to the last possible time to do that. But these people have said, Trump's lawyers, we're going to be vindicated by the United States Supreme Court. Well, when they have the opportunity to go to the Supreme Court, because special counsel Jack Smith said, this is an extraordinary case, Supreme Court, you want to hear this right now because this affects our democracy. When the response date came for Donald Trump, December 20th, his lawyers filed a opposition to special counsel Jack Smith's petition, and they said, nope, let's just go through the normal process. Let's not rush this to the Supreme Court. They even said haste makes waste, and that we should not be doing this too fast. Karen, talk to us about this filing by Donald Trump's lawyers today before the Supreme Court. I mean, it's such a cop-out after all of the things that they were saying. And just even from your perspective as the number 2 at the Manhattan District Attorney's Office, you don't shy away from the relief that you want if you believe you're going to win. It's a fairly basic concept, huh?
Well, his whole plan is to delay. That's what he wants. He doesn't want a ruling on the merits. He doesn't want this trial to ever happen. And so I think that that's partly what he's trying to do here. And That's why he just wants us to go slow, because by not having a trial, in some ways, that's the win. Because if the American people actually see the evidence that Jack Smith has and sees the evidence against him, that's crushing for him and frankly fatal to his attempt to become president again. So he does not want that coming out. He does not want people coming in and swearing under oath and being cross-examined, and to see what a just absolute liar and thief and insurrectionist he is. So it's almost like winning by losing, right? And so he needs them to just slow this down so that the trial doesn't happen. They get close to the election. The American people don't get to see the evidence, and they don't get to have the information about whether they are voting for a convicted felon or not. And so his entire request to the Supreme Court here is all about delay and why it should delay and not get to the merits. And, the most interesting thing to me was how different the question presented is between what Jack Smith says the question presented before the Supreme Court is and what Trump says. And that's something lawyers do, is they always, especially in the Supreme Court, they have to say, what is the question before you? And they frame it, right, in a way to kind of say, this is what you're answering to the court. And both sides kind of gave their own version. And I loved the way Jack Smith framed it, which is, this case presents a fundamental question at the heart of our democracy, whether a former president is absolutely immune from federal prosecution for crimes committed while in office, or is constitutionally protected from federal prosecution when he's been impeached but not convicted before the criminal proceedings begin. So I think his question is perfectly and succinctly put. But then you get to Trump's question presented, and he claims that Jack Smith misstated the legal issue before the court, and that Jack Smith was framing it as to whether absolute presidential immunity extends to crimes committed while in office. Instead, Trump says the question should be whether the doctrine of absolute presidential immunity includes immunity from criminal prosecution for a president's official acts, those performed within the outer perimeter of his official responsibility, and whether the impeachment judgment clause, Article 1, Section 3, Clause 7, and principles of double jeopardy foreclose the criminal prosecution of a president who's been impeached and acquitted by the United States Senate for the same or closely related conduct. So it's all about slowing it down, right? So what they could have done and what they could have briefed and frankly should have briefed if they wanted to really just slow this down, is brief the issue of whether this should be expedited or not, because that's what's before the court, right? Is what Jack Smith has put before the court is, this should go fast. And this is extraordinary. And we want to skip over the DC circuit and do a cert before judgment. And we know this is extraordinary. But what Trump is doing is he's not only saying slow it down, he's also briefing the issues, which I thought was interesting. And it gives a little bit of a window into what he was saying. So what he basically said was go slow, not at, quote, breakneck speed. He says in 234 years of American history, no president has ever faced prosecution for official acts. Until 19 days ago, no court had ever addressed whether immunity from such prosecution exists. And to this day, no appellate court has addressed it. So what he's saying is Jack Smith leapfrogged the DC circuit, so no appellate court has ever ruled on it. And 19 days ago, that's when Tanya Chutkan, the federal judge overseeing the case, that's when she ruled on presidential immunity. And so this is so complex and so intricate and so momentous that the court should take its time, do ordinary procedures, wind its way through the appellate courts. Don't rush to decide the issues with reckless abandon. Haste makes waste. I mean, I felt like I was reading a romance novel, just the phraseology here, reckless abandon. It's just this breathless hysteria that he presents to the Supreme Court. But essentially, his arguments were that the government lacks standing. And the reason I think it's important that we go through some of these arguments, Ben, because really the question here, again, if you're looking at the law, there's no way Trump wins ever. And I also think, practically speaking, if you're looking at the legitimacy of the Supreme Court, there's no way he wins also. There's no way they can rule that a president has absolute immunity, here, and then have the Supreme Court still have legitimacy. I mean, there's just no way, for example, if you take it to its extreme, that the president could shoot someone while in office and not be prosecuted criminally for it, or that you have to be impeached and convicted by the Senate before you can be criminally prosecuted, which is what Trump is looking for. But that has nothing to do with it, right? The impeachment clause of the Constitution is all about removal from office. It's not about criminal punishment, but he's trying to say, because the Constitution says that in order to remove a president for office and then thereafter prosecute him, he has to be impeached and convicted. And because, if you recall, he was impeached here, but not convicted because there's a partisan Senate, right? So he was not convicted by the Senate at the time. It doesn't say that's the only way to prosecute, right? It's just it just provides the remedy. So he's kind of taking two concepts and trying to mush them together. But he essentially gives the Supreme Court, I think, arguments if they want to do his bidding. Because I agree with you, they can't rule that he has absolute presidential immunity. But if they want to do his bidding, they can slow it down. They don't have to go fast, and they can rule on it later. And so that way, it doesn't, the case gets paused, it doesn't get ruled on. And then we've talked about the parade of horribles that can fall from that if he is then elected president. He can pardon himself. He can dismiss the case, have his own attorney general dismiss the case. I mean, there's so much mischief and havoc he can wreak if that were to happen. So if they want to do his bidding, that's what I predict they will do. Hopefully they won't. Hopefully they'll say, no, this has to go. And because that's how important this is and how monumental this is. And I'm hoping they see the gravity of it. But all they need is to buy one of his arguments, right? And so one of the things he says is the government lacks standing to appeal from this judgment and go straight to the Supreme Court, because you have to be injured in order to appeal. You have to get a ruling not in your favor. And Chutkan ruled for Jack Smith. So he wasn't injured. You know, the special counsel's office wasn't injured. They're not an injured party, and therefore the prevailing party is not allowed to appeal, right? From without there's no jurisdiction for this court. And he said the only delay, or the only injury, I should say, would be a trial delay, but that wasn't caused by Chutkan's decision either. So that's the one issue that I think that they really work hard to develop, to say that Jack Smith doesn't have the ability to go straight to the Supreme Court. And so, again, if they wanted to do Trump's bidding, they could say that and say, oh, let this wind its way through the appellate courts. It'll get to us. We'll rule on it eventually, but we don't have to go fast because, it's too quick. And this is so complex. And that's another thing Trump was saying, that this is so complex and there's no reason to rush. As you said, haste makes waste. So I think that's going to be one potential area to look out for. That I don't think they're going to rule, however, now on the fact that this was purely official acts. I don't think that's something that they will say and then say, therefore, he has immunity. I just don't, that argument, I think, has almost no merit. And I also don't think that they are going to say that the clause in the Constitution that says, that essentially argues double jeopardy, and also saying that you have to be convicted by the Senate in order to be prosecuted criminally. I also think he's going to lose there. So we'll see. We'll see how it goes. But he's making the nothing to see here. We don't have to go fast. This requires deliberation, and this requires time, and haste makes waste, as you say. So I think that's his argument, and hopefully the Supreme Court won't buy it, because hopefully they will see that by delaying here, you're essentially handing him a win.
I want to be objective here in the analysis. That's one of the things people like about this show. So, the strongest argument that Trump makes, but he oversells the argument with this haste makes waste garbage and that this is some very complicated issue. If he was a little more surgical about it, the best argument is, look, the DC Circuit Court of Appeals has already set a very expedited review. So there's oral argument before the DC Circuit now on January 9th. All of the paperwork is due by January 2nd. So, Supreme Court, we could get a ruling as soon as January 15th or January 20th. So, Supreme Court, you asked us to respond on December 20th. We may hear from the DC Circuit Court of Appeals by January 20th. And then certiorari is worth a discussion then. But why skip the DC Circuit when they are expediting it at this pace? That to me is the only argument, frankly, that they should have made, and it's a practical argument. I think they lose credibility when they start haste makes waste, and this is so complicated, and that these are official acts. It's just so obvious what they are doing here and what their strategy is, and I think it makes their lawyers, frankly, look foolish. By the way, I think that's a theme that Donald Trump always does in court, and I think that the lawyers are trying to appease him, and also you kind of get the lawyers you deserve. Like when we talk in a little bit, for example, about the experts in the New York Attorney General civil fraud case, one of the things that Justice Arthur Engoron said is like, these guys that Trump called in have zero credibility. Like they would have had some credibility with me if Trump's experts acknowledged that there was some fraud that took place, because some of the stuff that's so obvious. But when an expert looks at fraud and says, oh, that's just a mistake, and then calls all the fraud mistakes and says it can't be fraud if it exists in paperwork because fraud is always concealed, like you're just demeaning all of our intelligence, and you're going way too far, and you revealing your true intentions. Like that's what Trump, to me, the misfire that was made in his opposition to what Special Counsel Jack Smith is requesting. And then, I just want to go back to the point that, again, if this was a slam dunk argument for Donald Trump, if any MAGA trolls are watching this or listening to this, or if there are people who are on the fence in the issue who are not trolls, who just are wondering, like, I don't know how I should feel about this issue. Why would Donald Trump not want this issue to be resolved by the Supreme Court if he feels that it's a slam dunk, where he's appointed 3 of the justices to the court and 3 more justices are right-wing justices for a 6-3 right-wing majority that exists on this? Why wouldn't you want that? That should be a gift. And also, if Trump lawyers were saying that's what they wanted from day one, and now they have the opportunity to get that, and now they're arguing against that, to me, we could overcomplicate this, but that tells you, to me, everything that you need to know about what's up here. And then I do want to remind you, though, regardless of what the Supreme Court does here, as I stated, the DC Circuit Court of Appeals, in the meantime, they've expedited all this briefing. Trump's appeal is due December 23rd. Jack Smith's is due December 30th. The reply papers from Trump are due January 2nd. And then on January 9th is oral argument before that panel. And then I think you'll have a situation where certiorari could potentially take place after that, or the Supreme Court may just say this isn't really this isn't that difficult of an issue. Like, no. The reason this hasn't been addressed before is because it's kind of a very simple answer. No, you don't. You don't get to be a criminal when you're in office and then claim that you have absolute immunity for it. It just makes no sense on its face. So I think, the more complicated issue, Karen, is not in the criminal context, even though I don't think it's complicated at all. Like, if you wanted to say the Blassingame decision maybe has some layers of complication because it involves civil lawsuits where this doctrine of absolute presidential immunity was recognized, and you want to make some hay about it, even though I think the D.C. Circuit Court of Opinion was spot on, election and campaigning activities outside Article 2, at least you want to slice and dice Nixon v. Fitzgerald and Clinton v. Jones and play around with that. You can't be a criminal in office, try to overthrow democracy, and then claim absolute presidential immunity. Put it this way, for the self-interest of the Supreme Court, if they embraced a concept of absolute presidential immunity, they would put themselves out of business, because that means technically, if you take it to the extreme, a president can declare themselves dictator, arrest all of the members of the Supreme Court, and then claim absolute immunity for it. So that wouldn't make sense at all. It goes against Marbury v. Madison. It goes against the very central tenets of the judiciary. So the timing is the key here. We're going to keep an eye on that, and we'll keep focusing on that.
If you like what you just saw or heard, join us every Wednesday and Saturday on Legal AF. You'll hear either from me or Michael Popak or Ben Meiselas, where we will break down the most consequential legal issues that are facing us right now, where there's the intersection of law and politics. Join us and the growing movement of almost 2 million people on the MeidasTouch network, where you're arming yourself with information, you're learning the truth, and you'll make your own decisions, and we'll try to save our country. Thanks so much for listening.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.